Mr. Kopel.
Thank you, Chairman Graham and Ranking Member Feinstein. I support laws to remove firearms from people who pose...
Turn your, there you go.
I support laws to remove firearms from people who pose an extreme risk, not based on some lesser standard as some bills with an extreme risk title, but very different text do. In 2018, the Conference of Chief Justices asked the Uniform Law Commission to draft model legislation. I served on the Uniform Law Commission's study committee on the topic. While the study committee members had very diverse expertise and viewpoints, we were nearly unanimous that the Uniform Law Commission should move forward to draft a fair and thoughtful national model. Unfortunately, the Uniform Law Commission's efforts were shut down by lobbying from gun control organizations. As they frankly stated, they did not want any competitor to their own model, which in my view is dangerous and unbalanced. Federal funding should reward states only for best practices which protect civil rights and public safety. The first problem to address is the frequent misuse of ex parte confiscation orders against innocent people. Any procedure that allows a judge to hear only one side of a case necessarily will produce a very high error rate. Data from the two states with the oldest confiscation laws so illustrate. In Connecticut, confiscation orders may be issued ex parte. Later, the respondent will have an opportunity to tell his or her side of the story in court. In Connecticut, once the respondent does have a chance to tell his or her side of the story, 32% of confiscation orders are overturned. A study in Marion County, Indianapolis, reported similar results. Error rates for newer laws are likely to be even higher. Connecticut requires that a petition be filed by 2 law enforcement officers, and they must have conducted an independent investigation. Indiana likewise requires that petitions be filed by law enforcement. But some states allow petitions to be filed by a very wide variety of people, not just family members, but even including ex-girlfriends and ex-boyfriends or distant cousins, who may have had little or no contact with the individual for years. These states have no requirement for corroboration of any evidence. Indeed, Colorado's House Bill 1177, which will soon become law, legislators removed a requirement that evidence be corroborated. Unreliable procedures for ex parte orders ensure that a very large amount of orders will be issued against innocent and peaceable individuals. The problem is aggravated by mandates in some states for automatic, no-notice surprise confiscation, which may be perpetrated by no-knock raids. One person, Gary J. Willis, a 61-year-old black man, has already been killed by that system. Last November, a month after Maryland's new confiscation law went into effect, police in Ferndale, Maryland showed up at Mr. Willis's house at 5:17 a.m., announcing they had come to take his guns. They talked for a while, then argued, and then the police shot him to death. The victim's niece said that her late uncle likes to speak his mind, but wouldn't hurt anybody. "I'm just dumbfounded right now," she continued. "They didn't need to do what they did." In the Maryland-style systems, a respondent never receives notice of anything until the police show up to confiscate his or her firearms. This creates an inherently volatile and dangerous situation for law enforcement and the public. The safer approach is to authorize no-notice or no-knock confiscation only when a court has made specific factual findings about why such an approach is needed. Given the dangers imposed by autopilot confiscation, it is no wonder that so many sheriffs around the country are refusing to put their deputies and the public in harm's way to enforce a confiscation order that has a high possibility of being wrong and that can easily be obtained by a spurned former dating partner or a distant relative. As detailed in my written testimony, government attorneys sometimes discourage people from having counsel at these hearings, even at their own expense. A former Connecticut prosecutor bragged about how he talked respondents out of using lawyers. Colorado is taking steps to prevent such abuse by making court-appointed counsel available to all respondents. But a lawyer can't do much if she is prevented from cross-examining adverse witnesses. Some states eradicate the right of cross-examination. The accuser and witnesses supporting the accuser need never testify in court, where they would be subject to cross-examination and where the judge could observe their demeanor and make a decision about credibility. Instead, persons can simply submit an affidavit. In some states, the petitioner will never be seen by a judge or by opposing counsel. They can make a telephone call at an ex parte hearing and then immunize themselves from cross-examination at a later hearing simply by filing an affidavit. States that thwart cross-examination, promote unnecessary no-notice, no-knock raids, may have or leave innocent victims without a civil remedy for false or malicious petitions, or which deny other core elements of due process, should not be rewarded with federal funding. Federal funding should support best practices and not the worst. Thank you.
Thank you all. That was excellent. Gives us a lot to think about. Sheriff Bradshaw, Mr. Kopel, what state do you think has it most right?
I think Vermont sets a good model in terms of the ex parte proceeding. In Vermont,
I wouldn't have picked that one, but that's good.
Okay. And in Vermont, ex parte confiscation can only be ordered when there is the judge finds that there is an extreme and imminent risk. And Vermont also has, and confiscation can be ordered later after a due process hearing.
Do most of these states have a clear and convincing evidence standard for final disposition?
For final disposition, that's correct. But the one problem is the ex parte standards, hearings can be on such low standards.
I got you.
Mr. Kopel, these laws that we're talking about gives a judge an opportunity to take a gun away from people that are a threat to themselves or other people, but it also comes up against the Second Amendment right, and I'd quote, everybody knows this quote, "The right of people to keep and bear arms shall not be infringed." So, would you agree that the appropriate level of judicial scrutiny for the Second Amendment is strict scrutiny?
It depends on the particular law, but this case, which deprives people of having a firearm in their own home, yes, at least strict scrutiny.
Okay. Would you agree, same person, would you agree that it would be inappropriate to deprive U.S. citizens of their constitutional rights, even temporarily, without robust due process protections?
Yes, because the period when somebody is disarmed is a period when they're vulnerable, and without good due process protections, these laws can be abused by stalkers and other domestic abusers who want to temporarily disarm their intended victims.
Isn't it possible, Mr. Kopel, that some of the red flag laws that have already been passed by state legislatures could be held to be unconstitutional because they don't have enough due process protections in place?
Certainly, that would often depend on state laws, but for example, some states say that the right of cross-examination in all cases, not just in criminal cases, is an essential part of civil rights and due process and the common law.
This would be your opportunity to give some suggestions to them. What due process protections would you recommend for red flag laws?
In addition to the strict controls on ex parte proceedings, only having those when there's a showing of necessity and not making them a matter of default, providing counsel for all the accused or the respondents, and I think having a robust civil remedy for people who were falsely accused. Again, we know from Indiana and Connecticut that about 30% of these are wrongly issued. Now, sometimes those are maybe just a matter of good faith mistakes, but other cases it could be abuse in family disputes or romantic breakups and other situations. And there is the technical possibility of a perjury prosecution, but those are very rare almost throughout the country, even more so in civil cases. So I'd say the victim of a false or malicious petition should have the right to a civil remedy to recover attorney's fees and damages. And in addition, whatever restrictions states have on their no-knock raids should certainly, such as in Colorado, require the district attorney to get a warrant from the court before a no-knock. Those should apply to these kinds of confiscations as well. And unfortunately, the Colorado bill doesn't include our standard protections against no-knocks.
Okay. Various state laws and bills that are in Congress have varying standards that include substantial likelihood, probable cause, preponderance of evidence, and clear and convincing evidence. What is the appropriate standard that you'd like to see in red flag laws if Congress were to legislate?
The standard of proof at both at the final hearing and at the if there's an ex parte hearing where there's no opposition, so it should be fairly easy to win that one, should be clear and convincing evidence. And I think if we're going to have truth in legislation, when a bill says it's about extreme risks, then the standard should be a finding of an extreme risk, not a finding of some lower level of risk, or as in some legislation, merely finding a danger. Well, anti-gun advocates would probably say that every citizen who has a gun poses a danger, so that's much too low a standard. Clear and convincing finding of extreme risk, I think, would be upheld by the courts as compliant with District of Columbia versus Heller.
Well,
Mr. Kopel, have you ever met Congresswoman Gabby Giffords?
I have not. I've met her. I sat next to her husband, Mark Giffords.
Turn on your microphone. Could you turn on your microphone, please?
Turn your microphone.
I'm sorry. No, Senator, but I did sit next to and meet her husband, Mark Giffords, when he and I testified before this committee a couple years ago.
It's interesting, you didn't mention her name in your oral testimony, but in the written testimony submitted to the committee, you've mentioned her 18 times.
The Giffords organization, yes.
Yes. And the point I want to make is that many of us sitting at this table have town meetings. She had a town meeting on January the 8th, 2011. A gunman came into that meeting and killed 6 people, including a federal judge and a 9-year-old bystander girl, did damage to her, which she still struggles with to this day. And this gunman, whose background has been described, is, let me just read it to you if I might. I'm not going to mention his name, he doesn't deserve it. Acquaintances say his personality had changed markedly in the years prior to the shooting, a period during which he was abusing alcohol and drugs. He'd been suspended from a local community college because of bizarre behavior and disruptions in classes in the library. After his arrest, 2 medical evaluations diagnosed him with paranoid schizophrenia and ruled him incompetent to stand trial. What point I would like to make to you is Congresswoman Giffords is one of our colleagues. She was doing what we do every day. She went to a town meeting just as Ms. Wilcox's daughter went to work. Her life is forever changed and 6 people lost their lives. I believe that we ought to err on the side of protecting innocent people. I hope you believe the same thing. I'm glad you didn't mention her name in your oral testimony, but I have a great admiration for her and her husband and the battle they have fought ever since, so that innocent people like her, just going about their daily lives, don't become victims of someone who is clearly in a position where they should never own a firearm. I also want to say a word about your comments on domestic violence abusers. You have some pretty strongly stated views here about abusers abusing this system. And yet when it comes to the National Coalition Against Domestic Violence, they support these laws, which are a vital tool to protect people experiencing crises that make it temporarily unsafe for them to possess a firearms. These are the experts on the subject. They don't buy your point of view.
Well, I support these laws too, Senator. That's why I'm here testifying. And I would just remind you that with I'm glad you didn't mention the name of the Arizona criminal. As I detailed in an article in the Howard Law Journal, there was already all the procedures in place under Arizona state law to have that person confined for mental health evaluation. The Pima County Community College, where he was attending, dropped the ball. They expelled him because he was known to be dangerous to them. And if they'd simply taken one more step and notified a local sheriff's office or someone like that, he could have been taken care of under existing laws.
Mr. Kopel, let me tell you, existing laws did not save the lives of 6 people killed by this man. What we're talking about is a step forward to protect innocent people like Laura Wilcox and others beyond the existing law, which by its definition may provide protection, in reality did not. And what we're trying to do is come to a safer conclusion. Sheriff Brent.
What's next? One quick question, Mr. Kopel. Is Arizona involved in trying to pass an extreme risk law?
It was up in the legislature last year, didn't pass, and I presume it's a matter of legislative activity again. But again, whatever the pros or cons on that, the man who attacked Gabby Giffords, there were all the tools there to have dealt with him beforehand.
Yes. Senator Cornyn.
Of course, one of the things, I think, Mr. Kopel, you mentioned that something about protective orders in domestic violence disputes. Interestingly, as I recall the law, if you are the subject of a protective order, you are already legally disqualified from purchasing a firearm under existing law. Is that your recollection?
That is correct, with some details on the facts of the protective order, yes.
Right, right. And Mr. Hahn?
There is a great deal more we should do, but the right approach, I think, is targeting and focusing on bad guys. And I do think that extreme risk laws of the kind we're discussing can potentially be part of the solution set. That targeting those that pose an extreme risk, that have serious mental illness and pose a threat to themselves or others, is a law enforcement tool that can be helpful in preventing crimes of violence. Now, as has been noted by several witnesses, policymakers have to balance the need to protect the public safety with also the obligation to protect constitutional rights and to protect civil rights. And so, Mr. Kopel, I wanted to ask you, in your view, what are the minimum protections that an extreme risk law should have to ensure that to comport with due process?
Sure. Use of ex parte proceedings only on a finding of necessity, as we have in Federal Rules of Civil Procedure 65. You can't normally just get a TRO against somebody because you think you have a good case. You have to demonstrate to the judge specifically why the other party isn't in court today and what attempts you made to contact that person, and if you're sufficient, then you can get the temporary restraining order. So ex parte orders only on a showing of necessity, a clear and convincing standard throughout, because if we're eventually going to have a hearing with a clear and convincing standard, an ex parte hearing ought to be a fairly easy thing to win with no opposition. Right to counsel, including ideally providing appointed counsel for respondents, guaranteeing their right of cross-examination, for public safety and avoiding trouble, a Vermont-style system where the subject of an order, the respondent to an order, may surrender the guns either to law enforcement or to a federal firearms licensee, a gun store, or to another responsible person who will store the guns and keep them away from the respondent, and a civil remedy for false or malicious accusations. Those are what I'd say is the core, and obviously my 27-page testimony gets into some more features, but those would be the most important.
And am I understanding you right that in your judgment of the different states that have enacted these laws, you think Vermont's is the best constructed and strikes the best balance?
In those regards, I would say that Connecticut has probably the best procedures for starting things because they require anybody, dating partners, employees, teachers, anyone can go to law enforcement or to a state's attorney's office, but there's the filter of having a law enforcement or state attorney's decision on bringing it, and Connecticut specifically requires that there must have been an independent investigation. You can't merely proceed on allegations that have no corroboration.
One of the things that you discussed in your written testimony was efforts of some of the gun control organizations to block the drafting of a model red flag law in the Uniform Law Commission. Can you describe that at some additional depth?
Sure. So when the Conference of Chief Justices, which represents obviously all the Chief Justices of the 50 states, and I believe the territories and the district, asked the Uniform Law Commissioners, which for over a century has been drafting model laws on many, many topics, to create a national model law. And obviously, it wouldn't be a uniform act that everybody has to adopt or implement unchanged, but a national model law for states to use as their starting point and adapt to their circumstances. And so we had a in-person meeting of the study committee that was created for this in late November of last year, and then 2 telephonic meetings which had some of the original people there and then additional people. And we talked and argued some about different topics here, like ex parte, among others. And then the head of the committee took a poll and followed up by email voting, and all of the comments, except from one organization, were, yes, let's go ahead and do this, and we'd be happy to participate in the process. And the one organization that has its own very different model, which I view as going way to the extreme, said, no, we don't think you should do this because obviously it'll be a competitor to our group.
Which organization's that?
That was the Giffords organization.
All right, thank you.
About the differences in these laws, you noticed, you pointed out that Connecticut, you said you think in many ways their initiation process is an ideal one, and I take it you think that because it requires a state's attorney or assistant state's attorney or a law enforcement officer to initiate the proceedings. Can you just say more about why you think that is a good process that's protective of due process?
Sure. As there are lots of people who might know about somebody who does pose an extreme risk, but and there are also lots of people who might, just as they take advantage of lots of other laws about alleged child abuse or domestic violence and things like that, you know, in ugly divorces and in situations, false accusations do happen, sometimes often. And so Connecticut has, I think, a good filter on that, which is anybody can go to law enforcement and then ask them to initiate this petition. And law enforcement then has two officers or a state's attorney has the obligation to conduct their own independent investigation, and based on that, they go forward. Now, even so, we still have a high error rate, 32% error rate, even with the law enforcement as the filter. But I would suggest that that's probably
That's in Connecticut,
Connecticut,
32%?
yes. Yes. But when you broaden the scope of anybody who can come in for any reason, sometimes with good intentions and sometimes not, that would tend to, I think, make the error rate even worse. And in Colorado, certainly a lot of the legislative testimony we've heard about the bill that's before our legislature has been many women who were in divorce proceedings and said, I'm terrified of this bill because because the Colorado law allows a huge number of people to initiate. And as a woman said, if this bill had been around when I was getting divorced, my husband absolutely would have used it against me. And we've heard that from many, many people. So I think the law enforcement judgment is an important part of practical due process protection.
What do you think are some other states whose procedures across the range here are good models as you look at these laws?
Well, the Colorado law has something, it's not quite law yet, but it's going to be, provides for court-appointed counsel for all respondents. I think that's an outstanding feature, and that's exactly the kind of thing that federal funding could encourage. Vermont does a good job at de-escalating, the popular topic, I think, among everyone on this panel, de-escalating the confiscation process. Instead of having the law enforcement automatically show up and say, ex parte, I'm here to take your guns. Instead, the person who's subject to the order can, rather than having the guns hauled out by the police, can give them to a federal firearms licensee like a gun store or another responsible individual. And obviously that's something that has to be done quite promptly, but it's less confrontational than forcing law enforcement to walk off with someone's guns. Sometimes there are situations where law enforcement absolutely should, but that doesn't always have to be the mandate. That can be more the judgment of the officers and the courts.
Great, thank you. Thank you, Mr. Chairman.
Thanks, Mr. Chairman. Let me begin by thanking the chairman, Senator Graham, for his courage and insight.
Mr. Kopel, you are the research director of something called the Independence Institute, which has received over $1 million from the NRA, and the NRA's driving purpose is to represent companies that make and sell guns and to withstand all efforts on our part to enact sensible gun legislation. So one wonders how objective you are on the issue of safer gun laws. But let me ask you and Mr. Hornberg this question. Almost 25 years ago, the Congress passed something called the Dickey Amendment, referenced by Senator Booker, which prohibits the Centers for Disease Control from using federal funds for doing research into preventing injuries from gun violence. Do you think that makes sense, that we would be so afraid of research that we have to set aside the use of federal funds to study the impact of gun violence in this country?
Was that a question to me, Senator?
To you and to Mr. Hornberg.
Well, I suppose one of the things...
Very briefly.
Briefly,
Yes or no? Do you think this even makes sense to set aside the study
Your
of the
question
impact
isn't,
of gun violence?
your premise on the Dickey Amendment is incorrect. The Dickey Amendment forbids use of federal funds for advocacy. It does not forbid federal funds for research.
Well, advocacy is often in the eyes of the beholder. So, Mr. Hornberg, would you like to weigh in?
I'm going to respond just to the question about research. I think today what we've been talking about is an evidence-based approach to preventing gun violence, and I think the more research we can do to learn what can be done to prevent gun violence and some of the tragedies that we've been talking about today is something that we would strongly support.
So you don't think it makes a lot of sense to have to be so afraid that we're going to set aside prohibit the use of federal funds for, you can call it advocacy research?
Well, I don't know enough about the Dickey Amendment to comment specifically on that, so I really wanted to just.
Well, it's as I described it. So I would say that if you care about fact-based research, you wouldn't want to set aside money that would be otherwise available. Ms. Wilcox, thank you for all you've done to turn your grief into action. And you spent many hours in Sacramento explaining the benefits of red flag laws to California.